Very good morning, students. I'm Dr. D. Anita Kumari, Associate Professor of School of Management Studies, Wales Institute of Science, Technologies, and Advanced Studies, Chennai. So, in today's session, we are going to see the fundamentals of contract law and formation of contract act, the Indian Contract Act 1872. In this title, we are going to discuss about various formation of contract, Indian Contract Act 1872, what are the essential elements of contract, classification of contract, case studies, along with the examples. So before starting this unit, let's see the objectives of this unit. To state the meaning of contract, to create a simple contract, to state the essential element of contract, to understand the various classification of contract, to aware the rules related and formation of contract. So law of contract meaning, the law of contract is the most important branch of the business law or commercial law. Even it is the base of business law. It have a vital significance not only for the business world, but also for every one of us. As we all enter into a contract, one of one kind and the other in work of our daily and routine life. So each in our routine life, every day we are entering in a contract with one person. So the contract may vary. So at the end of this class, you could be able to understand different different kinds of contract and the meaning of a contract. So what are the things supposed to do at the time of entering a contract? So for example, when one buys and borrows the essential as well as luxuries for his life, in the form of goods or services from the early morning to the late evening, during the life period, one naturally enter into the contract. Bread, butter, home appliance, clothes, books, stationery, journey tickets, or some of the goods and services we buy or borrow in our daily life, everything is called as some type of a contract. So this is the definition of a contract. Every agreement and promise enforceable by law is a contract. So what is called enforceable? Which is acceptable by law. Which is acceptable by law is called as an enforceable. You cannot say that all the agreement is a contract. No, all the agreement cannot be called as a contract. For example, A and B entering in an agreement to kidnap somebody. It is an illegal one. It is not as a contract. The agreement might be anything. Okay. Offer plus acceptance equal to promise. Promise plus consideration equal to agreement. Okay. So the agreement might be anything. When two parties entering in a agreement for any kind of a personal purpose, that is called as only the agreement. But the agreement which is acceptable by law is called as a contract. An agreement which create a defined an obligation between both the parties in law of contract. A contract is a deliberate engagement between competent parties upon a legal consideration to do or to abstain from doing some act. So Indian Contract Act 1872 enacted by the Parliament of India, date enacted in the year of 1872, April 25th, date commenced on 1st September 1872. Total sections are 238, extended all state of India except the state of Jammu and Kashmir. So the Indian Contract Act consists of the following two parts. The special kinds of Contract Act. So here I mentioned here. So section of 175 of the Indian Contract Act came into the force September 1, 1872. And section 124 to 238 of the Indian Contract Act, these special contract act, indemnity, guarantee, bailment, pledge, agency. So already we have discussed about all the special contract in the previous video. If you have not seen the video, at the end of this video, you could able to view all my past videos link in the description box. You can view it. Okay. So all the special contract coming under the special kind of a contract, whereas general principle of law contract is coming under the section in between 1 to 75. So as I told you, offer or proposal, acceptance and promise. For example, I want to sell my car. So I am offering a car. I am proposing to sell my car. The another party is ready to accept it. So when offer and acceptance is joining together, that is called as a promise. Offer or proposal, when one person signifies to another person, when one person show his willingness to do something or willing to offer something, that is called as an offer. The another person once he accepts it, that is called as an agreement. Sorry, acceptance. The offer plus acceptance equal to called as a promise. The promise and promisee. There are two parties already we have seen in the last class, promiser and promisee. The person who is proposed the contract is called as a promiser, whereas who is accepted it is called as a promisee. For example, I would like to sell my car in the sense, in this example, I am the promiser. The person who is accepting is called as a promisee. So see this diagram, an agreement and legal obligation. The center part is called as a contract. It means that when an agreement which is accepted by law is called as a contract. All agreement are contract, but all contract are not an agreement. So what is this? So contract equal to agreement plus enforceable by law. So there are basically two types of contract, that is bilateral contract and unilateral contract. So what is called bilateral? What is called bi? Bi means two. When the contract is existing between two persons is called as a bilateral contract. For example, see, the buyer promised to pay a price, the seller promised to give a goods. See, the one person who make the offer, the another person accept it. So when the contract is created between two parties, that is called bilateral contract. Whereas unilateral in the sense, when offer is made to many of the offerees, okay, that is called unilateral contract. For example, I lost my goods. For that, I have given an advertisement in the newspaper that if somebody find my missed goods, for that some reward will be given. So like that here, I am the offerer. I am giving offer to many of the person, many of the offeree. Where unilateral contract in the sense, when one party is exchanging his promise or exchanging his offer to many of the person is called as a unilateral contract. Agreement enforceable by law is plus a contract, as I told you. An agreement which is enforceable by law is a contract. So see this proposal, promise, consideration, and agreement. And the agreement which is legally enforceable is called as a contract, which is not enforceable is called as a void agreement. Essential elements of a valid contract. So in 5 marks or during your examination, if you get a questions like define agreement or what is agreement, what is contract, if they are ask, if you find this kind of a questions, if you draw this equation, you will get a full mark. Okay, offer plus acceptance equal to promise plus consideration equal to agreement, enforceable by law equal to contract. So what is called consideration? The benefit. Whenever two parties enter in a contract, what kind of a benefit is exchanging? For example, I want to sell, I'm selling a goods to one party. The another party is giving a cash. Here, cash is called as a consideration. What kind of a benefit is exchanging between two parties? That is called as a consideration. For example, I want to sell my car. Here, I'm offering. The another party is accepting. This offer plus acceptance equal to promise. Promise plus consideration. What is called consideration? Here, I'm giving my car. He is paying a money. Okay, so that consideration is the money. This two, promise plus consideration equal to an agreement. The agreement which is acceptable by law is called as a contract. The various formation of a contract. An enforceable agreement is a contract only if the contract is valid. Valid means which is acceptable by the law. The requirements of a contract are as follow. There must be an offer and acceptance. There must be a consideration. Party must be competent to the contract. There must be free consent of the parties. The object of the contract must be lawful. These are the 10 essential elements of a valid contract. Offer and acceptance, legal relationship, consensus ad idem, free consent, capacity or competency of the parties, lawful object, lawful consideration, certainty and possibility of performance, agreement not declared to be void, and legal formalities. So these are the essential elements of a valid contract is given in brief. So agreement is between two parties. Agreement in the sense it will consider the legal relationship. Whereas consideration is a legal, detrimental, lawful, and bargained for. Whereas consent, sometimes it become not valid when it is fraud, misrepresentation, and undue influence and mutual mistake. Whereas the legality can be classified as a two, objective and subject matter, and writing. Capacity in the sense the person who entered in a contract, they must have fulfilled the condition of the Indian Contract Act 1872. So as I told you, let's see the explanation for the essential elements of valid contract. So what is called offer plus acceptance? Always all the contracts supposed to fulfill the essential conditions. 10 points. First point, whenever two parties enter in a contract, There must be offer from one party. There must be acceptance by another party. That is called offer and acceptance. As well as it should create a legal relationship. What do you mean legal relationship? The parties must intend their agreement to result in the legal relations. This means that the party must intend that if one them of fault to perform this obligation, the other party is face some losses. That is called as a legal relationship. For example, see the example is given here. Offer in the sense there needs to be a proposal from one side and acceptance from another side. This proposal might be sometime implied or expressed. You know what is called expressed orally or in written basis. One person will be offering something to the other person. Same way, the other acceptance also will be done by oral or either written basis. For example, if we take like commercial activities in the sense, people used to offer their products over by email by giving some quotation or tender or whatever it is. The other person will be accepting it by written format only. Okay. So some example is given here. The two person name A is a wholesaler and B is a retailer. They came into the agreement where A promised to give a goods to B at the wholesale price, but in case A did not do the same, B can sue him. Okay. So in other hand, B invited A to his daughter's wedding. A promised that he will show his present, but then he does not go, then B cannot sue. See, there is a difference between these two. Since this is not somewhat, some valid contract. Okay. Whereas here it is a commercial based one. So we have to consider this two examples. So this is a live example, Bulkler as well as the Bulkler. So the construct of intention is to form a case study. This is a case study actually. The construct of intention to form a legal relationship was understood within the case of Balfour and Balfour. During this case, the suspect United Nations agency was utilized on a government job in a Ceylon, visited England along with his married person. For healthy reason, the married person was unable to accompany the husband to Ceylon. The husband secured to pay 300 per month as a maintenance to the married person for the time she lived apart. The husband did not pay the amount and was eventually sued by his married person. In this case, it was commented that the husband was not prone to pay and there was no intention to form a legal relationship between the parties. So can you able to understand the case study? In case Buffalo was Buffalo, so husband and wife, they moved to some place due to some official purpose. As the wife, she could not able to continue to stay over there due to the healthy reason. So husband, what he said, you better go and stay in your native. I will give you every month 300 rupees as a some take care of the home things. I will be giving you 300 rupees. But he has not given the 300 rupees. For that purpose, the wife, she has sued the husband in a court. But the case was very favored to the husband. Why? Because he has not given any written document that I will give you 300 every month like that. So since the case is favored to the husband. So here also another case study is given. In this case, the abdomen on servant RDC versus Paul 1942. In this case, a person who received a service from a fiber brigade under the impression that the area was entitled to free services had to pay the fire bridges when he found out that the area did not service charge free. He had made an implied promise to pay for the service while availing of benefit. So like this, some of the case studies given at your free time, you can go through. So consensus ad idem. What is called consensus ad idem? Agreeing upon same thing in a same sense. So for example, when two parties enter in a contract, both the party must be clear for what purpose they are entering in a contract, what is going to be exchanged, what kind of a consideration is involved. For example, I'm having one workshop. I'm selling the second-hand cars. Okay, so here one customer is visiting shop. He wants to buy a car. I misunderstood that he is going to buy the car which is above the 2 lakh. But actually, the intention of the party is to buy a car which is worth of only 1 lakh. So what I will be doing, I will be showing the car which is more than the 2 lakh. Whereas later on only I came to know his intention is different. So like this, when two parties entering in a contract, they're supposed to be clear. That is called agreeing upon same thing in the same sense. That is called consensus ad idem. both the parties must be clear for what purpose they are entering contract, what is going to be exchanged, okay, what is his willingness to buy or sell. Everything supposed to be very clear under the consensus addendum. What is called free consent, that is willingness. An agreement must have been made by free consent of the parties. The content is said to be free when it is not caused by coercion, undue influence, fraud, or misrepresentation or mistake. That means when two parties entering in a contract, it must be free from any kind of forceful or threatened. That means both the parties willingly they have to enter in a contract. You should not force anybody else to enter in a contract. For example, I have given a case study here. Ranganayaga Kama versus Alvashati. Actually, the Ranganayaga Kama, he's a male. Okay, he is a husband of Alvashati. Alvashati is a wife. Okay, Alvashati in her 14 years of age itself, she got married with the Ranganayaga Kama. Ranganayaga Kama unexpectedly he died. Okay, so Ranganayaga Kama, he is having too much of assets. He is a wealthy person. So what the relatives of Ranganayaga Kama felt is they forced the Alvashati to adopt one of the child in the family, in the same family. Why? Because they don't want the they don't want the relations of the Ranganayaga Kama. They don't want the property and the assets of Ranganayaga Kama to go in Alvashati hand. Okay, because since they are newly married. Okay, so unexpectedly he died. Obviously, as per the Indian Contract Act, the husband's property will be given to the wife. So to avoid such situation, the Ranganayaga Kama relatives, they forced Alvashati to adopt the child. They also threatened her, in case if you are not going to adopt the child, we will not allow you to do the rituals of your husband. Because the husband's body still is there in the home, they are not allowing her to do any rituals. So what she decided, okay, she wants to fulfill all the conditions. Why? Because she wants to complete the rituals of her husband. So she accepted. She adopted the child. So after a certain period, she filed a case against the relatives of the Ranganayaga Kama. Now the judgment is favored to the Alvashati, the wife. Why? Because since this contract is missing from free consent. What do you mean with this? Because Alvashati is forced to adopt the child. Okay, so she has not willingly adopted the child. Okay, so this is one of the example for the free consent. Capacity. The parties into the contract must have a capacity, a legal ability to make a valid contract. So age of majority, with a sound mind, person only can able to enter in a contract. There are certain parties who is not able to, are eligible to enter in a contract, like unsound mind, and the person who is insolvent, the person who is forbidden by law, the person who is a minor, he cannot able to enter in a contract. What is called lawful object? The reason for what purpose you are entering in a contract, it must be valid one. It must be a consideration or object of the agreement is unlawful if it is forbidden by law, or is of such nature that if it is permitted or would defect the provision of any law, is fraudulent, or involves, implies injury to the person or property of another, or court regards is immoral or opposed to the public property. So whenever the parties, two party entering in a contract, it should not be prohibited by law or forbidden by law, or it should not create some injury to others. For example, A and B entering in an agreement to kidnap somebody, or to murder somebody, or to damage somebody's property, okay, or to cheat somebody. So these are all is not called as a lawful object. So whenever parties enter in a contract, they must follow the lawful object. So these are all the person. A person should attain the adulthood. As I told you that minor cannot make the contract. It should be a sound mind. A drunkard person not allowed to make a contract. The person should be there should not be an insolvent. So some case study is given here. Krull versus Henry. For this situation, the respondent consent to release a level of offended by party. Watch the crowding ordinance of King. So students, due to time constraint, I am just skipping the case study, during your free time, you can put that particular case study name in Google or YouTube. You can view. If I have a time, in the next class, I will take all the case studies as a single presentation. Competent to the contract, already I told you what is called competent to the contract. Anyhow, one example is there. Competent in this contract, and I told you that student, the particular person, is supposed to be a major person, is supposed to be a sound person. He should not be a minor. So some case study is given here. Srikakulam and Subramaniam versus Kuruma Subba Rao, 1948. In this case, there was a minor and the minor's mother who sold a piece of land to the discharge of a debt of the minor's father. This property was mortgaged. Subsequently, the minor had second thought and claimed that the contract was void. The Privacy Council found that the contract was within the competency of a guardian. The contract was thus enforceable since the mother contracted on behalf of the minor. The contract had also been made for the benefit of the minor, that it was a void contract. Okay. So some case study is given here. Mohinder Singh versus State of Punjab. This is an example for lawful object. In this case, a person who was elected as a span bench for a period of 5 years made an agreement with another member that the later would be given 2 years term and the elected one, remaining 3 years. The agreement was held to be void as it would have a defected the purpose provision of the Punjab Panchayat Raj 1994. So as I told you, what is called lawful consideration? Consideration means something in written. That means quid pro quo. That means whenever the two parties are entering in a contract, there must be a benefit. There must be a benefit entered in the contract. For example, as a seller, if I'm selling any kind of a goods, I need to receive a cash. That cash is called as a benefit here. Something in written, that is called as a consideration. Not expressed. Apart from this, there are certain contract, essential of contract to be fulfilled. Not expressed, declared to be what? That means that sometime the law itself might have clearly mentioned, if you are going to do this kind of a contract, it is not a valid, it is a void one. For example, if you are entering in a contract, if you are if you are exporting the sandalwood, if you are exporting some other goods which is prohibited by law, if you are going to involve in such a contract, that is called as a void contract. Then what's the possibility of performance? What is called possibility of performance? As I told you already in the last class, what is called possibility of performance? At the time when they enter in a contract, that the nature of the contract must be in a possible one. Okay. For example, the magician entering a contract with one person and saying that I will give you the birth or life to the dead body. Is it possible? No. As well as the magician entering a contract and saying that I will convert all the sand into the diamond. Is it possible? No. So what is called possibility of a performance? When two parties entering in a contract, the reasons or the nature of the contracts must be in a position to perform. It must be in a position to execute. That is called possibility of performance. Necessary legal formalities. A contract may be oral or written. So always the contract must be either in a oral or written format. That's all. The essential elements of a contract over.